It's great to welcome you back as we're continuing our investigation of the United States Constitution. We're looking a little bit at the roots of this great document, the original sense of it as best as we can discern it, and certainly the way in which it's been applied and, in my opinion, at times misapplied down through the years. So we're looking at all of these aspects of American constitutional history in this short series. I've mentioned, of course, that I believe that the Constitution itself is measurably a product of the Reform side, especially of the Protestant Reformation. And right now, you may know that we're looking at the religion clauses, and I would include these also as a good expression of the long-term effects that would be traced back to the Reformed wing, the Calvinistic side of the American Revolution. We mentioned last time that the two clauses that are called the religion clauses include, on the one hand, the Establishment Clause, which really stands for the idea that the government cannot help any particular religion too much. And of course, on the other side is the Free Exercise Clause, which I would say is the reverse of that the Congress cannot hurt any particular religion too much. Somewhere in the middle of those two bookends, we have what we call religious freedom. And it may surprise you to hear that I'm suggesting that really the notion of religious freedom does once again trace back to the Protestant Reformation, and especially the Reformed wing of the Protestant Reformation. Now, I'm not saying it just came out fully formed, right at the time. These things take time, and it was about 200 years, of course, after the original Protestant Reformation that we begin to see this particular idea fully formulated. But even at the beginning, you at least see the traces of it coming on the scene. You think about the Calvinistic side, pretty much from the beginning began to recognize what was called a right of immigration. Now, that was a bit of an innovation, up until that time. Each country had its official religion, and if you weren't willing to conform to that religion, then you could pay a very stiff penalty for that, up to and including death itself, maybe burning at the stake. That wasn't uncommon, of course, at the time of the Protestant Reformation. The Reformers began to think, and especially in the Reformed side, that, rather than burning people at the stake, we might give them the opportunity to just, immigrate. Go somewhere where they'll find their beliefs are a little bit more compatible with those of the environment, and that would be an alternative that would probably be more desirable. And that particular view was somewhat innovative even at the time. It's very interesting. One of the most ironic illustrations of this is from the life of John Calvin, and the rather infamous incident in which Michael Servetus was burned at the stake. You know that story. I don't know how many times I've heard Calvin slandered as, Calvin burned Servetus at the stake, that kind of thing. If you're familiar with the story, then you've probably heard expressions like that. Oddly enough, Michael Servetus, in his case, really illustrates the very point I'm making. If you don't know the story in detail, I'm not going to go to it right now. You could go back to my church history series. We cover that in somewhat greater detail. But just the point I want to make at this time is that Servetus was, of course, a Unitarian. He was viewed as a heretic by all of the Christian world. He was already sentenced to die in a Catholic country. Somebody was able to orchestrate his escape and maneuver, really facilitate him winding up in Geneva, probably in part to embarrass John Calvin, because they were really hostile. I mean, Servetus had attacked Calvin rather frequently and rather vigorously over the recent years. And so there's Servetus now showing up in Geneva itself, which at that time was dominated by Calvin. He wasn't a politician. He didn't hold any political office. He wasn't even a citizen of the city, actually, but the influence he wielded was essentially the power of the pulpit, the power of his pen, that kind of thing. But anyway, Servetus shows up in Geneva. The city fathers, of course, the city council of Geneva, knew he was there. And they said to him, look, you're free to stay here. You're here on a refugee status. But you need to understand that we do have laws in this community, one of which is a law against public heresy. Now, we may or may not like a law like that, but obviously we can't judge 16th century standards by 21st century values. We need to be very careful when we don't start retrofitting our own view of things back 500 years earlier. But the city fathers said to Servetus, okay, if you want to go somewhere else where you'll find a more compatible relationship with your community, you're free to go. That was the principle of immigration. Servetus did not have to stay in Geneva. He was free to leave. But he was also told in no uncertain terms, if you stay here, then you have to mind your P's and Q's. You can't start publicly endorsing what is universally viewed as heretical teachings of the Christian faith by every branch of the Christian movement. If you do that, you're going to get in some trouble. Servetus minded his manners for a while, but of course eventually he couldn't contain himself, and he basically was found in violation of the law. He was accused of a crime. He was convicted by a jury. Calvin wasn't there. He didn't participate in the trial. But anyway, the sentence was rendered that he should be burned at the stake. Well, that was Servetus' own decision, you might say, in some ways. Calvin actually weighed in trying to have a more humane form of execution applied, but the city council turned him down, and Servetus was indeed burned at the stake. Well, my point is that Servetus did not have to come to Geneva. He didn't have to stay there. That it was the Reformed side that said, look, you can go somewhere else if you want. That was a principle of immigration. That was still in the 16th century. By 100 years later, the idea of religious freedom had become quite a bit more conspicuous. You know that Holland was probably leading the way at that time with the principle of religious freedom. You've heard of the Dutch Reform, that's the Calvinistic community. They dominated in Holland at that time, and they basically established a principle of religious freedom, not a sort of a dictatorial imposition of a particular religious view, but the true sense of religious freedom and so on. That's why the Pilgrims who were being persecuted in England fled to Holland, because it was a place where they could practice their religion without being intruded upon by the state. Of course, the Pilgrims and the Puritans and the Presbyterians eventually wound up in the colonies, because even there you could find more an idea of religious freedom. But even in the colonies, there was still established religion. 6 of the colonies had religions that qualified as established religions. The others didn't. But eventually the idea of religious freedom became even more conspicuous, especially after the Great Awakening and the widespread effects of the preaching of George Whitefield, and of course the rise of the new side Presbyterians. Roger Williams was one of the first voices. He was a Calvinist. He came out of that tradition. He established Rhode Island and said, look, we're going to have religious freedom here. And eventually that idea spread to the others, so that by the time we get to the Constitution, you could say that the principle, which had at least been conceived in the Protestant Reformation, was now beginning to take shape in a more full and complete expression. And these 2 clauses that we have here, the Establishment Clause and the Free Exercise Clause, are really intended to give us some idea of an official policy that stands for religious freedom. It's not pluralism. It's not saying that every view is equal to the others. There was no idea here that, whatever you believe is okay just because you believe it. That's sort of a postmodern notion, But it was the idea that the message of Christ can stand on its own 2 feet, that the message of Christ is self-authenticating, and that we don't need to pound into people some sort of orthodox religion, that we can let the marketplace, you might say, determine in each person's life what they're going to do, and that does seem to be the best course. And as I say, I think we can trace it back then to the Protestant Reformation and so on. Well, this time I want to pick up really this discussion of the religion clauses. Last time we were looking at the 2 of them, and I gave an introduction, and I indicated there was one footnote I want to include here at the beginning of this conversation, which will trace out one particular more recent development that especially is related to the Free Exercise Clause, and so that's what I would like to examine. But once again, before we get started, let's just ask God's blessing on our time together. Our Father, we're grateful to you that you have given us the opportunity to share together in this conversation. We pray that through the presence of your Spirit you would give clarity and insight, understanding, such that what we look at this point will be faithful to what actually happened in history, and will also be faithful to the truth that you wish for us to communicate. And we pray that we would all do so in a way that honors Christ, in whose name we pray. Amen. All right, well, as I say, we're talking about the Free Exercise Clause. There's a case that really came along in 1990, which is called Employment Division versus Smith. This was a case involving 2 Native Americans who had been using peyote, which, as you know, is a hallucinogenic drug. It happened to be outlawed to use hallucinogenic drugs in the state in which these 2 men were employed, and so they were fired, and they made a claim for unemployment, and the claim was turned down because, in fact, they had been fired for cause. And they sued in federal court, and eventually that case wound up before the United States Supreme Court. Now, the point here is to say that there were two different ways that the Supreme Court could evaluate the issue. Of course, the Native American fellows, they were claiming free exercise. They said, you know, this is our religious principle and practice, and so we should be given an exemption based on the fact that we have these kind of deeply held religious convictions. The court could have said, well, look, we're going to apply the Sherbert test. Now, I mentioned the Sherbert test last time. It's a four-part test, but really it boils down to two fundamental questions, a sort of balancing act between, on the one hand, the interest that the religious person has in practicing their religion and the interest that the state has in overruling that practice because it's found to be contrary to the broader public order, maybe injurious to it or something like that. The standard that the state has to show under Sherbert is what's called a compelling state interest. And so you have a compelling state interest on the one hand, balanced again this religious practice on the other. If the state can't show a compelling interest, then the religious practice should be allowed. But if the state can show a compelling state interest, then of course the religion should be prohibited. Well, that would be the normal and expected basis upon which this case would be determined. What's interesting about the case of Smith is that the court actually decided to use a different basis to reach its conclusion. And the basis was not compelling state interest, but was rather what's called a neutral, generally applicable law. Now, there's a difference there. You have to kind of think like a lawyer here, so I'm going to try to work through this, and I hope you'll kind of get the fundamental idea. But those are two different standards, and they hold the state to two different levels or burdens of proof. So on the one hand, if you're saying a compelling state interest, that's a fairly high standard. The state has to really show at a fairly high level of the burden of proof that the position that it's taking is justified and warrants overruling or prohibiting the free exercise of the religious people. A law that's called a neutral law of general applicability doesn't require the same standard. This is just a general law that applies to everybody. It doesn't single out a particular religion. It doesn't aim to inhibit anybody's practice. It's just a general law. A speed limit law would, for example, be a good example of a law that's neutral and generally applicable. Well, the problem is here that if you take that standard, that lower standard, then it's much easier for the state to prove its case. If it's just a neutral law, then that's not nearly as difficult as proving a compelling state interest. And what happened here in the Smith case was the court opted for that neutral law. A much lower standard, and of course they had no problem, therefore, upholding the decision not to pay unemployment benefits to our Native American friends there. But there were many at the time who thought, wait a minute, you could have used the higher standard, probably reached the same conclusion. Why would you apply a rule that only demands a showing that the law was neutral and generally applicable? Especially given that historically that rule had been used to allow for religious exemptions, you see. That was the point. For example, if you go back to a case known as Yoder, that was an Amish case. I mentioned the Amish last time. This is a different case. But once again, it was the Amish who sort of clarified this little point of history. The Amish had a rule that once a child had gone to school through the 8th grade, then they should be able to leave formal education and begin to learn a trade. That was the Amish way of life. That's what they had done for years. And that was challenged because in, I believe the state was Wisconsin, in that state there was a rule that a person had to go all the way through high school. So you can see a conflict here. The Amish wanted to let their children learn a trade after the 8th grade. The state had a different rule. Well, the rule to stay in school through high school would be a neutral law of general application. And when it was applied to the Amish were able to show, well, hey, wait a minute, we've got this practice, it's part of our religion, it's part of our culture. We say that children should be able to learn a trade after the 8th grade, and the court actually agreed. And so the Yoder case came out in favor of the Amish, and so that was kind of a typical example of a case in which a neutral law of general application would allow an exemption in the case of someone like the Amish. Well, the court, however, used that same rule, the same rule that was used in the Amish case, but came to a different conclusion. And the case that it used to rely on that is a case called Gobitis. The case name was Minersville School District versus Gobitis. Now, Gobitis was a school child. He was in elementary school, but he was a Jehovah's Witness. And his Jehovah's Witness religion had told him that to salute the flag was an act of idolatry. The leader of the Jehovah's Witnesses at the time was a man by the name of Judge Rutherford. That was his name. He was a lawyer, and he was a pro tem judge occasionally. And he had told his people that you shouldn't salute the flag. That's idolatry. Rutherford had taken over this movement from actually the founder of it, who was named Charles Taze Russell. So originally the Jehovah's Witnesses were called Russellites, but now they were called Jehovah's Witnesses. That was the name that was applied by Rutherford. Well, Gobitis, this child, of course, through his attorneys and so on, sued the school district for wrongful ejection because the school district had booted the kid out because he wouldn't salute the flag. And there was a general law, a neutral law, generally applicable, that people should salute the flag. Judge Rutherford himself actually argued the case before the U.S. Supreme Court. He lost. The court ruled 8-1 against Rutherford, against the Jehovah's Witnesses, because they said that this law was neutral, it was generally applicable, it was intended to promote national unity. This was at the time of the Second World War. And so it was viewed as a rule that really did seem to have a good justifiable purpose. And that's the case that the Smith court used. The problem was, after Gobitis, there was widespread hostility against Jehovah's Witnesses. Really, I think any of us would be embarrassed to see some of the things that were done to Jehovah's Witness people. Whatever you think of Jehovah's Witnesses, they were treated to all kinds of vandalism and public displays of violence and that sort of thing. And all of it seemed to be warranted by the reaction of the court in Gobitis. Well, the problem became so widespread that the court seized an opportunity to revisit the issue sometime later, and that was the case known as Barnett. And so we have West Virginia Board of Education versus Barnett. Again, similar fact situation, once again taken up by the U.S. Supreme Court. And at this point, the court reached a different opinion, you see, on similar facts, ruling, in fact, that the free exercise clause would prohibit forcing students to salute the flag. In fact, the Barnett case gave us one of the most profound and really eloquent statements of the principle of religious freedom that we've ever had in the history of constitutional interpretation. I remember hearing this paragraph for the first time when I was in law school and being really impressed with it even then, and to this day you'll often see it mentioned in cases that involve this particular issue. But the language says this, quote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or any other matters of opinion, or force citizens to confess by word or act their faith therein. And if there are any circumstances which permit an exception, they do not occur to us now." Well, it would seem that in Smith, the court could have used Barnett, but of course they didn't. In fact, they rather surprisingly concluded that Barnett was not decided on the basis of free exercise, but actually was based on the principle of free speech. And instead they went back to Gobitis, you see, and using Gobitis, they reached the conclusion that they reached. Now, I'm not saying they reached the wrong conclusion. That's not the point. I think they would probably reach the same conclusion either way. But the fact that they used Gobitis, of course, threw very much into question the entire disposition of the court toward the free exercise case, because now all of a sudden it becomes a rather sort of unexpected outcome that might lead to rather unpredictable outcomes in further cases that might be brought before the U.S. Supreme Court. Because now we're saying that there is no religious exemption even from a neutral law of general application, that no longer is it possible to use that as a basis to argue for free exercise because the state is held to a much lower standard. So there are all kinds of cases that might have been decided differently had the case been decided the way the Smith case was. Just a few examples just to illustrate the point. There was a prior case in which a Presbyterian church had dismissed the church organist because it was discovered that he was a homosexual. You see, now that was seen as violating the moral code of the Presbyterian church. They dismissed him. He sued. He lost because, in fact, the compelling state interest was found not to be applied in that case to cause this person to retain his position. Under Smith, it's not so sure whether that case would come out the same way. Most churches, or I should say most states, have churches that will serve alcohol to minors in communion, in the sacrament. Now, you might say that that violates a law because virtually every state has a law forbidding serving alcohol to minors, but an exception has been allowed for churches doing it in the sacramental context. Under Smith, not quite so sure you'd get the same outcome, you see. Some churches decline to hire female pastors. That's based on church teaching, on a reading of the Bible, and so on. That's fine. But traditionally, that particular practice has been upheld. But under Smith, it's not so certain that that would be the outcome. You see the point. There are certain cases that have been decided based on a prior understanding of the burden held by the state, which under Smith, that burden has been reduced to the point that you might find cases would come out differently as a result. And so that did provoke a rather striking reaction in our culture. You may recall, this is back in the early 90s, what was called the Religious Freedom Restoration Act, RFRA, it was sometimes called. It was actually intended to try to fix the evident problem that had come as a result of the Smith case. That's how important the case was and how concerned people were about its outcome. The RFRA legislation basically had two fundamental principles. One, it affirmed the four-part Sherbert test, the compelling state interest test, must be applied, and it also expressly allowed for religious exemption from neutral laws of general applicability. So it's really trying to undo what had taken place with respect to the Smith case that took place in 1990. In 1993, you might remember this, RFRA was passed by both the House and the Senate by a respectable majority in each. But in 1997, the Supreme Court overruled or basically rejected RFRA and said the reason was because Congress was now introducing its interpretation of the Constitution instead of the interpretation that had been applied by the Supreme Court of the United States. And so right now, RFRA, of course, is no longer applicable, and the Smith case continues to be the order of the day. In constitutional history, it hasn't been there for that long. There hasn't been a good test case yet to decide how firmly the court's going to remain committed to the standard of the Smith case, but at least it's something to be aware of. My point is that we have the Establishment Clause, the Free Exercise Clause. The two have held a pretty good balance in history, allowing for religious freedom, but now we have at least what appears to be a bit of a challenge, a bit of an erosion of the free exercise provision, which really means the state can forbid certain practices, and the state is only held to a fairly low standard to make that happen, whereas under the original Sherbert standards and the Barnett case, it would have been held to a higher standard. So something to be aware of. I'm not sounding the alarm here as some kind of catastrophe, but I am saying that certainly to be constitutionally literate and to think about what's happening in our culture, it's a good idea to have some of these things in mind. All right, well, moving on from the religion clauses, we have also in the First Amendment what are called freedom of speech and freedom of the press. So I'd like to take a brief look at these and just give a general overview as to what they mean and how they've been applied. Fundamentally, free speech means there can be no prior restraint to speech. We have a system that says if you want to say something, you can say it. And we don't permit the government to come through and sort of proactively and step in and prevent you from speaking in the first place. That's really the heart of what free speech is all about. But the caveat, and it's a fairly weighty one in that, is that freedom of speech is not freedom from consequences of speech. And so even though you're free to say anything you want, nevertheless, there may be consequences that flow from what you say, and the principle of free speech does not guard you from those. So anybody who is an author of a statement which represents some kind of damage to the social order may very well be responsible in some form or other for the speech that they have given. There's several different areas. I'm not going to give you an exhaustive list here, but I would like to mention the more important areas where this particular principle has been applied. One of them is called defamation of character. You know that defamation is when you make a statement about a person which is, number one, false, and number two, damaging. So if you make a false statement and it's a damaging statement, that person has suffered losses that are measurable, then you have become liable for defamation. Now, if your speech is spoken speech, that is oral speech, then it's called slander. If it is in writing, then it's called libel, but both of them are under the broad umbrella of defamation of character. Under the law, if the person who is injured by your speech is a private person, not famous or otherwise well known, then you're pretty much held to a standard of strict liability. This means that, you know, let's say you get an email from somebody and that email has defamatory information in it. If you just forward that email, you don't comment, you don't endorse it or reject it, you just forward it, you have become a publisher of it. And if the person who is damaged by it is a private citizen, you could be responsible just for pushing forward on your computer. It's something to be aware of, you know, but that applies to private persons. If it is a public person, meaning a politician or somebody else who's really well known in the public square, then the standard is quite a bit higher. And it's required for you to be held responsible for such an action that actual malice be shown. This goes back to the case of New York Times versus Sullivan. What is actual malice? Well, it's a deliberate falsehood or a reckless disregard for whether a statement was true or false and resulting damage that flows from it. That's the standard for people in political office. It's also the standard, pretty much the same thing, for famous people. These would be sports figures, movie stars, people that are really well known in the public square. Defamatory statements about them are held to this higher sort of bar, and it has to be a matter of actual malice. So that's one area where freedom of speech has had some interesting constitutional history. Another issue that's rather interesting is obscenity. I was frankly kind of surprised in law school at how much case law there was dealing just with the issue of obscenity. You know, it's kind of surprising to me, but there it was. The fact is, to this day, obscene speech is illegal. It can be punished. However, I think it's safe to say it's very rare, especially in these days of internet pornography and otherwise, to find people actually prosecuting crimes related to obscenity. The problem is compounded somewhat by the fact that it's sort of hard to define what exactly is obscenity. You know, one Supreme Court justice made a comment one time that he didn't know how to define it, but he sure knew it when he saw it, you know. That was his statement. It might be sufficient to get a chuckle out of a crowd if you hear that line, but it does speak to the issue of the problem you've got. You know, if a person makes an obscene statement, then how exactly do you know that it was obscene? That's part of the issue. The 73 Supreme Court actually wrote a three-part test trying to define what is obscene language. It didn't have much to do with the original intent of the free speech clause, but it was the court really trying to write its own statute here. But notwithstanding that effort, prosecutors have generally been not very willing to bring charges. The only exception is child pornography. That does represent a place where there's been a fair amount of litigation, and rightly so. I don't know, I suppose a brave attorney general somewhere could start bringing actions alleging violation of obscenity laws. The success or failure that that person would have is hard to say, but nevertheless, the potential certainly is there, and that's one area where freedom of speech has been somewhat curtailed by principles militating against obscenity. Another form of speech that's been interesting in this connection is called inciting violence. If your speech is likely to result in, and really intended to result in, immediate displays of violence in the public square, then that would be a violation. There was a case back in 1969 that was called Brandenburg versus Ohio. Brandenburg happened to be a leader of the local Ku Klux Klan. A public official had made some statements he didn't like, and he threatened what he called revengeance. Now, I'll tell you, I'm not quite sure what revengeance is, but he was actually charged with a crime for saying that, because it was called inciting violence. You see, that was the accusation. Well, the court later looked at that and said, no, as a matter of fact, using the word revengeance or similar words would be protected speech, and there was no violation of a principle avoiding inciting violence. The court said that the speech has to be directed at or inciting or producing imminent lawless action and was likely to incite or produce such action. I'll leave it to you to kind of describe what speech might do that, but you can imagine somebody calling right now, right here, for violent action. That would be inciting violence, and that would run afoul of the principle articulated here. What's been an interesting sort of experiment in this whole problem is what's called hate speech. Hate speech, obviously, is not necessarily sufficient to incite violence. It's simply speech that some people construe as causing offense to other people. And so it can be called hate speech. Well, the fact of the matter is there's no constitutional protection against being offended, you know. But hate speech laws have been enacted here and there, and you would say that's principally what they're intended to do. There's never been a good solid test of hate speech type laws in the U.S. Supreme Court, so we still don't know exactly what's happening or what would happen in that case, but we certainly know what lower courts have done along the way. For example, there was in 2004 what was going to be a pride parade, you know, and some Christians gathered to provide a counter sort of protest to this gay pride celebration. The Christians showed up, they had Bibles, and they had signs. So they had signs that had been printed on and so on, and basically the operative language on the signs was, quote, homosexuality is sin, Christ can set you free. And they used bullhorns to promote their message, which of course is also permissible. And these people were arrested for disturbing the peace. All right, well, maybe that was a good accusation or not. But the thing that was interesting was they were also accused of hate speech, because there had recently been enacted a law that prohibited hate speech. And so the question was, would they be criminally liable for hate speech violation under those facts? Well, a judge eventually ruled correctly, in my opinion, that that speech, though it was offensive to some, was in fact protected, that under the free speech laws of the United States, that would not be speech that would run afoul of the principle of free speech. And so that was the outcome. Similar cases have happened here and there from time to time, but the basic principle seems to be pretty healthy, that government can never silence speech based on content alone. There has to be something more to get the inciting of violence going on than simply saying something that somebody finds to be offensive. A similar case was Police Department of Chicago versus Mosley. In this case, a man was picketing a high school, just one man out there with a big sign. The sign said, quote, Jones High School practices black discrimination. All right, so that was the speech that was being charged with criminal behavior here. He was arrested. Once again, it found its way into a particular court, which again concluded the same thing, that that was protected speech. It might be offensive to somebody to see that speech, but that in itself doesn't rise to a constitutional violation. So that's an area to keep an eye on. As I say, the whole idea of hate speech continues to be somewhat in flux, and what the court would eventually do with it remains a somewhat open question. And finally, we have another area where this whole problem of freedom of speech has been somewhat interesting and controversial. That has to do with campaign finance. You may recall back when Hillary Clinton was running for President of the United States, that there was an organization called Citizens United, and they published a documentary which was opposing Hillary Clinton becoming the president. The case wound up before the Supreme Court. It was called Citizens United versus Federal Election Commission because the Federal Election Commission had said that they could not air this documentary within a certain time frame before the election itself. And so the documentary was ready to be published, really, but they were prevented from doing so. Citizens United filed suit against the election committee, and the Supreme Court found in favor of Citizens United. It noted very interestingly, this is interesting language here, the provision of the Bipartisan Campaign Reform Act, that Feingold Act we mentioned, prohibiting unions, corporations, and not-for-profit organizations from broadcasting electioneering communications within 60 days of a general election or 30 days of a primary election violates the free speech clause of the First Amendment of the United States Constitution. And so even in that case, it was found, although it was a little late, but it was found that that particular attempt to silence the voice of that documentary was in fact unconstitutional. It's worth noting in passing here that you'll often see legislation coming along that really does attempt to limit political donations. And invariably, if you take a closer look at such legislation, you'll see that it almost always favors the incumbents. It's one of those cases where it's a little self-serving, on the part of incumbents who are already in office to pass laws that we'll see have the effect of preventing challengers to their position from being able to get as much publicity as they would like. Such laws, I think, should be viewed with considerable skepticism by us voters. All right, the last thing I'd like to take a look at is called freedom of association. Freedom of association is based on the First Amendment provision that we have a right to peaceably assemble. Again, it's a pretty straightforward principle. If you decided to start a club and you wanted to use a public facility for your club to meet, and the purpose of your club, let's say, was to promote resisting illegal drug use, that sort of thing. Well, then if somebody who was, somebody that basically bought and sold illegal drugs tried to apply for membership to your particular organization, then, you would think you would have the right to decline their application for membership, even though you're using a public facility to do so. That's basically the principle. You have the right to pick and choose who's going to be a member of your association based on whether they share the values that are important to the purpose of your organization. The simple principle is the people have a right peaceably to assemble together to consult for their common good. And so you can imagine if you're an anti-war group that you could decline participation by people who are pro-military. If you're a group that opposes racial discrimination, you could decline applications for membership by white supremacists or black supremacists for that matter. If you're a church, then you could decline membership to someone who opposes your teachings. That's the idea. We sort of take that for granted. And interestingly, as much as that's been a part of the American way of life, it has been somewhat seriously challenged in recent years. The original rule was pretty much faithfully applied in the case of the NAACP, and there are several cases that actually did highlight the point that we're making here. In 1958, for example, the state of Alabama filed suit against didn't file suit, but it demanded of the NAACP that they disclose their membership list. And that disclosure of the membership list was found to be unconstitutional. It was a violation of this freedom to assemble. The court eventually, in evaluating the requirement here, said, of course, it is immaterial whether the beliefs that sought to be advanced by the association pertain to political, economic, religious, or cultural matters, and state action which may have the effect of curtailing the freedom to associate is subject to the closest scrutiny. The court decided that demanding that this group publish its membership list violated the principle of freedom. It said inviolability of privacy in group association may in many circumstances be indispensable to preservation of freedom of association, particularly where a group espouses dissident beliefs. Now, that's the traditional rule, and it was pretty much faithfully adhered to through the years, but we begin to see a little bit of loosening of the mortar, you might say, in more recent years. It all began with a group that was called the JCs. This is the Junior Chamber of Commerce. It was founded in 1920. Its purpose was to develop leadership skills among young men. And so as a result of that, they excluded older men from membership. They also excluded women from membership. Well, in 1984, Minnesota claimed the JCs were violating anti-discrimination laws, particularly at the point of their declining to accept membership from women. So the question that eventually was presented to the U.S. Supreme Court was, quote, was it a violation of the First Amendment's freedom of association to force this private civic organization founded for men to accept women as full members? The court considered the case, rendered an opinion finding against the JCs. It had a two-step analysis. It concluded, number one, the organization would experience no real burden if it admitted women, and at the same time there was a compelling interest to do the opposite. There was a compelling governmental interest to end gender discrimination. So after that case, called the Roberts case, basically similar clubs like the JCs lost their ability to some extent to even define their purpose and certainly to control their membership. That, of course, spread to other service organizations as well. The Rotary, Kiwanis, others, of course, had to follow suit to stay in line with what the Supreme Court had dictated. Another, a little bit closer call came some years later. This was the year 2000, in which a claim was made against the Boy Scouts because they had expelled a scoutmaster who happened to be homosexual. And the New Jersey court was basically filing suit, or actually the man who had been dismissed was filing suit, and a court in New Jersey, relying on the JC's case, found a compelling state interest of non-discrimination. The Boy Scouts relied on the earlier NAACP cases, arguing freedom of association, and they lost, but they appealed it to the U.S. Supreme Court. Basically the argument was that they, under the First Amendment, had the right to control their membership. Well, the Supreme Court found in favor of the Boy Scouts in the year 2000, ruling that the Scouts should not be required to send an inconsistent message. But it was a close vote. It was a 5-4 decision for the Boy Scouts. And basically the standard the court used was a little bit ambiguous. Not be required to send an inconsistent message is not exactly a good, firm, objective standard by which to evaluate similar cases in the future. So already we see that it's a bit of a soft standard that might be susceptible. And indeed the susceptibility of the standard became clear enough sometime later when another case came to the Supreme Court called the Christian Legal Society versus Martinez. This involved Hastings Law School. Hastings Law School required student groups, recognized groups on the law school campus, to sign non-discrimination policies. That included not discriminating against people based on the idea of sexual orientation. Well, the Christian Legal Society refused to sign that document, and therefore they were refused recognition as a law school recognized body. That meant they lost considerable benefits. And in 2010, the Supreme Court finally was able to rule on that. Again, it was a 5-4 decision, and on that occasion, it was against the Christian Legal Society. It was similar facts to the Boy Scout case, but it came out just one vote the other way. So the Christian Legal Society was not permitted to exclude non-Christians and was not permitted to exclude homosexuals from its membership list. So you see the Boy Scout case came down narrowly in favor of the Scouts. The Christian Legal Society came down narrowly against the Christian Legal Society. It's just a way of saying that in recent years, the original rule, which had been really developed rather clearly under the NAACP cases, has become quite a bit more in flux. And again, it's one of those areas where, as an informed individual, you want to keep an eye on that. You want to be aware that there's a certain trajectory of cases. The composition of the case or of the court can change occasionally, and sometimes that affects the outcome of such cases. but it's something, of course, that we should be concerned about. We should especially be concerned about it when we talk to our prospective legislators and representatives, asking them what their views are on some of these issues and how they would vote to affirm or not affirm people who are looking for positions on the highest court. Well, I hope that's helpful. That's going to wrap up really our treatment of the First Amendment. We're going to move on next time to the Second Amendment and other provisions of the Bill of Rights. I hope you'll be able to join us at that time, and until then, thanks for joining us, and we'll see you next time that we're here.